Good afternoon, everyone. Today is Monday, June 23rd, 2025. We're here this afternoon for a land use hearing. I call this meeting to order, and we'll begin with the Pledge of Allegiance. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Well, good afternoon, everyone, and welcome. My name is Kristen Stevens. I'm Chair of the Board of County Commissioners. With me are my fellow commissioners, Commissioner Jody Shattuck McNally and Commissioner John Kafalis. We have Frank Haug from our attorney's office with us, and Deirdre O'Neill, who will be helping us with note-taking and minutes for the meeting, and she's from the clerk's office. I'm going to turn things over to Jenny Axmaker, our planning manager, and she's going to give us a little information about today's hearing, some of the expectations, and she'll introduce the staff.
Thank you, Madam Chair. Joining me at the dais, we have Justin Curry, County Planner. We have Senior County Planner Samantha Mott. We have Ryan Oswendell and Christina Scrutchins from our planning admin staff. Across the way, we have Principal Planner Matt Lafferty. Then we have a new member of our engineering team, Bruin Johnson, joining us. We also have Connor Sheldon from engineering and David Pringle. Joining us from the health department, we have Ashton Brodall and Leah Schneider. With that, we respectfully request that all members of the audience silence their electronic devices. Please help yourself to a copy of the agenda and hearing procedure instructions, which are located on the wall just to the right of the entrance to the hearing room. And if you're joining us online, you can find those at larimer.gov/BOCC/commissioners-meetings. Please wait to speak until recognized by the chair. Please maintain civility, refraining from audience applause, comments, or disruptions, whether positive or negative. Anyone who is disruptive during the hearing will be asked to leave. Please make all comments to the Board of County Commissioners from the podium. A portable microphone is available as needed. Please state your name at the beginning of your comments and provide the spelling of your name if it's unique. Please speak directly into the microphone so that remote participants may hear, and the microphone on the podium can be repositioned to best capture your testimony. Questions may be asked during your testimony, but will not be answered until public comment is closed and the rebuttal portion has begun. Upon request, we do have assisted listening devices available for the hearing impaired. For those on Zoom, attendees will be muted until recognized by the chair. If an online attendee wishes to speak or requests that a consent item be removed, please use the raise your hand function on the Zoom control bar or *9 on your phone. With that, for the consideration of the chair, staff would recommend amending the agenda this afternoon to move consent item 3, the Jacobs Conservation Development, to the second item on the discussion agenda. And staff would also like to note that the Estes Valley code updates were tabled to July 28th, not August 11th.
Thank you very much, Jenny. So now I'll go through some additional information, including what is on our agenda today. So the first item was that tabled item, and so as the planning manager said, the Larimer County Code amendments for the Estes Valley emphasis file number 25 code 0283 will be heard on July 28th, 2025. And then we have several items on our public hearing consent agenda. And the first one is the Crawford Acres Lot 14 easement vacation, file number 25, land 4474. And this is a request to vacate a 20-foot water line easement that runs 92 feet across the southern portion of Lot 14 of the Crawford Acres subdivision in the Fort Collins area. The second item on the consent agenda is the Neubauer Conservation Development, file number 22, land 4225. This is a request for approval of a conservation development on 50 acres to create 2 residential lots, 1 outlot and 1 residual lot located in the RR1 zoning district. Then as the planning manager said, we will be moving the Jacobs Conservation Development, file number 21, land 4170 to the second item on the discussion agenda, so we'll have a full discussion of that. we will do that. And then the third item then on the consent agenda is the Van Hattem rezone sketch plan review, file number 22, zone 3311. This is a rezoning of 2 existing parcels from RR2, rural residential, to industrial light. This is in the Johnstown area. We have the next item, which would be item number 4 in the new agenda, Emissaries of Divine Light amended special review and appeal, file number 23, zone 3564. This is to approve buildings constructed and added to the Sunrise Ranch property and some unpermitted additions to buildings and structures. No new construction is proposed with this request, and it includes appeal to Article 4.3.6 of the Land Use Code regarding fire protection. And then the fifth item for the consent agenda is Land Use Code Amendments, file number 25, Code 0285. These are Land Use Code amendments, and those are different than the amendments that are being tabled. And then finally, there would be 2 public hearing discussion items. The first one would be the Mead Short-Term Rental Administrative Special Review, file number 23, zone 3497. And that is a review of a 3-bedroom plus 1 additional sleeping area, short-term rental in an existing home in the Loveland area. And then, like I said, the second discussion item will be the Jacobs Conservation Development, file number 21, land 4170. And this is a preliminary approval for a conservation development on 35 acres to create a residential lot, a residual lot with a 2-acre building envelope, and appeals to Article 5.3.1, a public right-of-way in the Land Use Code. So those are the items on both the consent agenda and the public hearing discussion. We will be, as I said, removing that one item, the Jacobs Conservation Development item, and moving that to discussion. And just so folks know, items that are on our consent agenda are considered routine in nature, and there's no perceived or significant controversy. It is why we are removing one of the items, because there has been some public comment that's come up since then in the Jacobs Conservation Development item. But in general, we would just adopt the whole consent agenda as read without a public hearing. So before we do that, I'm going to ask each commissioner, is there anything else you would like to remove from the consent agenda?
No, Madam Chair.
No, Madam Chair.
Okay. Then Commissioner Kofalis, I'll ask you to make the motion for this consent agenda. Oh, please.
We need to see if anyone in the
Oh, I'm
audience would
sorry.
like
We
to
need to
remove
ask
something.
the public. I'm sorry. I'm not feeling that well today. I'm a little out of it. Is there anyone in the public who wanted to remove anything additionally from the consent agenda? Mr. Lafferty.
I have nothing to remove, but the item that is being tabled is being returned to the Planning Commission for further input. So I just wanted the public to be aware that on July 16th, that item will go back to the Planning Commission, and we will be welcoming additional comment on that.
Wonderful. Thank you for that clarification. So last chance to remove anything that hasn't already been removed from the consent agenda. Is there anyone online who wanted to do that?
If there are any members of the public online who would like to remove any of the items on the consent agenda, please use your raise your hand function now. There are no hands raised.
Thank you. Commissioner Kofalis, now will you make that motion?
Yes, thank you, and welcome everyone. I move to approve the remaining items on the consent agenda, minus the Jacobs Conservation Development, subject to the conditions in the staff reports, and further move to authorize the chair to sign the findings and resolutions.
Thank you, Commissioner. There's a motion on the table. Any further discussion on this item? Seeing none, all in favor say aye.
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 That motion passes 3-0. The consent agenda has been approved. So if you're here for any of those items, I mean, you're welcome to stay, but you're also welcome to leave. So we will move on to our first item on the discussion The public hearing discussion item, which is the Mead Short-Term Rental Administrative Special Review, file number 23, zone 3497. And just so folks understand how this works, we'll have a staff presentation. The commissioners can ask questions. Then we would have a presentation by the applicants. And then we would open the floor up to, and the applicants have 10 minutes to speak. Then we open the floor to public discussion on that item, hear that public discussion. If there is public opposition to this item, we would give the applicants 5 minutes of rebuttal afterwards. And then during all those times, the commissioners can ask questions. After the rebuttal, we would ask any final questions and then move into deliberation. So those are how both public hearings will be run this afternoon. So we will begin again with our first discussion item, and I will ask for a staff report on this item.
Thank you. Good afternoon, Commissioners. My name is Samantha Mott, Senior Planner with Community Development. The project before you is the Mead Short-Term Rental Administrative Special Review. It's file number 23, zone 3497. The property is located at 4710 Swainsona Drive in Loveland. The legal description, it's Lot 10, Block 1 of the Lake Knolls South subdivision. It's part of an amended plat boundary line adjustment with Lot 10, Block 1 of a replat of Bodecker Park subdivision. It is located approximately 600 feet north of the intersection of 14th Street Southwest and Nadine Court, and about 750 feet east of the intersection of Swainsona Drive and Nadine Court. The current zoning district is UR1, urban residential, and the lot size is 1.17 acres. And you can see it's outlined in blue on that map. The owner and applicant is Karen Mead, and she is here in the audience today. The property manager is Bob McIntosh, whose address is 5 Frontier Place in Longmont, Colorado. And I wanted to point out that the property manager is located approximately 18 miles, 30 minutes away from the proposed short-term rental. The property is currently served by Little Thompson Water District, Loveland Sanitation, and it's accessed from Swainsona Drive, which is a public road. And the applicant has indicated in some of their materials that they're providing, it says 2 and 3. 2 are required, but they're showing 3 parking spaces. And it's in the Loveland Fire Protection Authority district. The request is for the applicant, is for a small short-term rental. And I wanted to mention that before the hearing today, there are a few copies of an addendum. The applicant originally proposed a 3-bedroom, 1 additional sleeping area short-term rental for a total occupancy of 8 guests, but has since revised her request, and it is an existing 3-bedroom, single-family residence with a maximum occupancy of 6 guests. That's 2 per bedroom. So they've removed the request to use the additional sleeping area and reduced the maximum occupancy from 8 to 6. Here's a site photo of the house looking from the street. Larimer County Land Use Code, I will point out that we did have new short-term rental regulations that went into effect on June 1st. This is one of the applications that was submitted prior to that date, so it is subject to the pre-June 1st, 2023 short-term rental regulations. So that's what we reviewed it with. As you can see, properties in the UR1 zoning district are allowed to go through the process and seek approval through the administrative special review. A short-term rental is defined as a dwelling rented to transient guests for short-term lodging when not occupied by the owner or renter. And a short-term rental is classified as a commercial use, and it's permitted, as I mentioned, through the administrative special review process if they receive approval. Community member notification was done for this project, and we notified approximately 39 properties within a minimum of 500 feet of the subject property. And the subject property is right here, if you can see my cursor, kind of just southeast of that cul-de-sac. Staff received comments from a total of 4 community members in opposition or with concerns, and those comments were attached as Attachment E. The applicant did provide a response to community member comments, and it's included in your packet as Attachment F. There is review criteria in the Land Use Code that is looked at to determine whether or not a short-term rental can be approved. So in reviewing a proposed administrative special review, the director looks at, there's general approval criteria in 638D, and also the following review criteria. That review criteria, 1 through 5, has been addressed in the packet, and I wasn't going to go over it here, but I'm happy to go back over it if I need to. One of the things I did mention in my staff report is that staff believes that this short-term rental has met criteria 3, 4, and 5, but it is unclear if 1 or 2 review criteria 1 and 2 are addressed, which is one of the reasons we're at this public hearing today. In addition to the review criteria, there's also use criteria for short-term rentals. As I mentioned, this is subject to the pre-June 1st, 2023 review criteria or use criteria, and so those are outlined here. I've also touched upon that in my staff report, but staff believes that all this use criteria has been met by the applicant. I did want to point out, this is just some additional information. Although this doesn't apply, with our new regulations, we do have a lodging facilities map, and we can't have short-term rentals within 500 feet of another approved short-term rental. So you see that little pinpoint and that yellow circle. It does show that there are no approved short-term rentals within 500 feet of this one. And I also wanted to point out that with our short-term rental regulations, regarding if the short-term rental is approved, the transfer of the short-term rental license, in this case, because it was not approved before June 1st, it could not be transferred to another property owner. It could only be transferred to a family member. So I just wanted to point that out. The process for a referral to the Board of County Commissioners. So an administrative special review can authorizes the director to approve applications by which all the criteria are met and there are no substantive issues. If the director determines that it's unusually complex or raises some unique or serious impacts, then they may refer it to the Board of County Commissioners. In this case, the planning manager acting as the director made the decision to refer this to the commissioners due to the neighbor comments and, as I mentioned, review criteria 1 and 2. Staff found that the administrative special review meets the use criteria, that 335B2, and 3 out of the 5 criteria in the land use code. We're not making a specific recommendation on the Meade short-term rental, and we've presented all the information by which the board may base their deliberation and decision. There are 2 motions, and I'm happy to pull these back up later. One motion is that the Board of County Commissioners can deny this request, and another option is the Board of County Commissioners can approve this request. And if the Board of County Commissioners do want to approve this request, staff has proposed a list of conditions of approval. A lot of those are standard conditions of approval that we do place on short-term rentals. And I will say that just if we get to that point, I did modify one of the conditions of approval to match the applicant's reduction in occupants for the short-term rental. And that concludes my presentation. I'm happy to answer any questions.
Thank you very much, Samantha. Any questions for Samantha before we move on to the applicant? Commissioner Cavallis.
Thank you, Madam Chair. Thank you, Samantha. I have 2 questions, and my second question might be more appropriate for the owner applicant. But my first question is regarding the 2 review criteria, 1 and 2, upon which we received comments from neighbors, community members. Were there any specifics provided? Because they seem like general comments regarding short-term rentals, generally speaking. I wonder, I reviewed those and I didn't see any specific examples of why folks might be concerned about this particular short-term rental. So that's my first question.
Thank you, Commissioner Cavallis. In looking at the neighbor comments, again, those are attachment E. I believe they were more general in nature, like noise, trespassing, traffic, the compatibility issue. I think one of the more specific ones was some concerns about an access area for the Lake Knolls recreation area.
That's right.
And I believe the applicant and possibly neighbors are going to speak to that.
Great. Thank you. One more question, please. And this one may be better suited for Ms. Meade. And that is, I think I read somewhere in the material that the proposal was for this to be used as a short-term rental part of the year, not throughout the year. And if I read that correctly, number one, did I read that correctly? And number two, does that mean that the applicant owner will be living at this house other parts of the year?
Thank you again, Commissioner Kofales. I do see in the project description that they did mention for a portion of the calendar year, but I believe the applicant could better speak to that question.
Okay, great. Thanks kindly, Samantha. Thank you, Madam Chair.
Thank you, Commissioner. Commissioner Shannon McNally, any questions?
I do not have any questions at this time. Thank you.
Thank you. Okay. Well, I'll ask the owner, the applicant to come up. I believe that's Karen. And welcome. And you'll have 10 minutes to state your case. And you may want to answer that question that Commissioner Kofales had posed to our staff too while you're presenting. And give 10 minutes, and you'll hear the little beeping sound when your time is up. Thank you.
No hook.
Was that no hook? No. No, maybe a gavel though if you're run way over. We'll see.
Well, good afternoon, commissioners. And my name is Karen Mead. My address, 4710 Swainsona Drive in Loveland. I did apply for a short-term rental for my property there. To answer your question, yes, this is my primary home, Commissioner Kofales, and I would plan on running it part of the year. This is my primary home. This is not like one of 6 rental properties, and I plan on having it rented continuously. The point of this was, as my kids move on, they're going to be adults, I thought it would be nice to have the option. And when the rules were changing, the county encouraged me, if you're going to do it now. So I went down the path to do the short-term rental, thinking that it would be some additional income in the next 1 to 2 years, and that would be invested back into the house to help cosmetically. The picture that was presented actually wasn't my house, but if you, and I don't have one to give you, but it needs siding, it needs some things, and I thought it might be a nice way to help do that and also add some value to the neighborhood, because mine is probably the ugliest one of the group. So I hope that answers your question there. Okay. So again, this is my only property. I believe today I want to address the 4 letters that came in with the opposition and concerns. I think I have a good solution, a proposed solution for each of these, and I'd like to chat a little bit about those. I know you had a letter at the end. I know I missed some things, so I'll just go through each letter and keep it brief. The first 2 letters I want to go for first. Great, that is the first page. The first 2 letters, the first one is they're both from the same household at the other end of my road, Swainsona. They're at 5030. So proximity to me, they're well outside that 500 mark, and they're on the west side. The first one's from Lori Dasco. She is the president of the Lake Knolls Recreation Area. I'd like to refer to that as the LKRA for time's sake. I should disclose, actually, I am a director in a director role on that HOA, because the HOA is the Lake Knolls Rec Area. Also, the Lake Knolls Rec Area owns the 2 parcels of lands that are of concern. The first one is an access road. That's the very small one you're seeing if we refer to the page A. And then the larger one is actually an easement. The concern is that they'll be trespassing on those 2 parcels of land owned by the LKR, which could potentially cause a liability issue. The access road on the west side has a lock gate on it. Granted, it is a short gate with no trespassing on it. It's a very small access road. I think more of the issue, my understanding, is that easement that you're seeing going north. There is a fence on the right side of it. There is a neighbor on the left side. My proposed solution to this, and let me say, I agree in Lori's letter, renters are not considered guests. In the HOA, there's a statement in the bylaws, it's for the homeowner and their guests. Yes, I'm not arguing that. Renters are not guests. My solution to this is remove the issue. I did a clear statement in the operations manual. That's page B, Samantha. That says there's no usable access to Bodecker Lake from the property. I also have a sample renter's agreement where I would have them sign that they understand that. There's page C, and I'm trying to keep this brief, where the arrow is, that's the property, a big 6-inch post that defines the property corner. And I would be happy to put a large sign there so people are clear. This is where the property ends. No trespassing, and an arrow. As far as the liability, I think if we removed the access and made it very clear that is in fact trespassing, I don't think that's going to be as much of an issue. There's a mention about trash. I have it clear in the operations manual how to handle trash. I'm not concerned about trash being on the easement. They've been told not to go down. The last concern is there's a mention that only a 6-foot fence would be a viable option. That is not a viable option across that access road for 2 very good reasons. One, there's underground utilities that go to my neighbor east of me on 14th. And there's also, let me make sure I call it the right thing, it's the Western Area Power Administration. And that is part of the United States of America Department of Energy. They have an agreement with Lake Knowles that they pretty much have any rights on those 2 pieces of property, those 2 parcels. They can enter, locate, construct, maintain, repair, rebuild. Full of time, they can do it, they can pave it. And I have that if you want to see it. That is an actual official agreement between the Department of Energy and Lake Knowles Rec area. A number of times when they go down, they bring very large trucks through there. They barely fit through the gates. And I don't have a choice as part of the United States of America, but a lot of times they will back up and go onto my property so they can turn them around. They need to. There's not enough room. If I put a fence, when I was chatting with them, they're like, technically, we can do what we want. If we need to take your fence down to be able to turn a truck around, we're going to. Therefore, I don't feel that is a viable option. Moving on to letter 2, again, from the same household of 5030, Mr. Sutton, his concerns are about a lawsuit that happened in 1989 regarding lake access. I was not part of the neighborhood at that point. My understanding, and they're welcome to add or correct or whatever, is that it was lake access, that they were trying to close off the lake access for neighbors in that development. That access ended up being closed, and part of this settlement, it was an actual lawsuit. Those 2 parcels were used. This is your access road. This is your easement. If you live on the non-lake side of Bodecker, which would be the south side of Swainsona, you have access to these 2 areas. And Lake Knowles Recreation Area will have an HOA, and if you're a member, you can use them. I'm not quite sure how that works. Since I'm a director, it hasn't been an issue for me. I don't believe that has anything to do with my short-term rental. A short-term rental wasn't part of this. It wasn't actually any one particular neighbor. It involved the entire neighborhood. So my thought is that it doesn't really apply to whether I have a short-term rental or not. I've already said they don't have access. The next concern was people driving through the neighborhood seeking lake access. Since these people are already renting from me and they've been told, I don't see why they'd be driving through the neighborhood trying to find access. Knocking on doors, that sort of thing. Since I've been there since 2019, the only people that have knocked on my door, granted, I'm not lakeside, has really been to find out if there's any properties for sale. And people are, I know they've got a lot of, what would you say it? Guts about them, to put it nicely, and they will come and knock and say, anyone in the area for sale? We've been trolling this neighborhood looking for something to go up for sale. So again, I don't think the trolling in the neighborhood looking for lake access concerns my short-term rental. The next concern addresses an Arizona rental. They have had trouble with their Arizona rental, and their letter states their home is surrounded by short-term rentals. That's not the case in Swain-Sona, and especially with the 500-foot rule. And as Samantha showed you, there are no short-term rentals, so it strictly has to do with me. Again, you may feel differently, but I'm not so sure the Arizona's problems are my problems. The last concern was the visual of the lake would promote trespassing. If we can look at page F. Okay, so page F, I'm showing you view from the driveway. You can barely see the lake. If you look like at the end of the fence to the right, yeah, right there, that's the lake. Or that's from the driveway, I'm sorry. The next one is the view from the front yard. Again, yeah, the lake's over there, but you're not real enticed to go through everybody trying to get to it. There's a lot of shrubs and stuff in between the two. If you go to page G, the next page, that's walking towards the easement. The top picture, you can see the lake in the distance. But the key one is right there, the bottom one. That is standing at the foot of the easement. You don't even know a lake's on the other side of it. There is no visual. You would have to walk down there to know that that's an easement to the lake. If there's a sign already saying, don't trespass, I don't see something enticing to walk down there. It kind of looks like it's part of Tom's property.
Okay, Karen, you are out of time.
Oh, okay.
We may, the commissioners may have questions for you. So,
Sure.
Are there any questions that anyone wants to ask before Karen sits down? Or
Madam Chair, I'd like to maybe hold my questions till after public comment, but I
Of
do have
course.
a couple. Thank you.
Of course, and Commissioner Kafalis.
Thank you. Thank you, Karen. Would you further clarify? So, this is your primary residence. So, how many months out of the year do you anticipate using it as a short-term rental, and then the remaining time you would live there?
Yes.
So,
I'm thinking collectively, because I wouldn't be doing it every week, maybe collectively 3 months out of the year.
and you would be living there 12 months out of the year or 9 months out of the year?
9 months out of the year.
Okay, great. Thank you.
Is it possible to add one thing or no?
If it was related to the question that Commissioner Kafalis just asked.
No.
Okay. All right. Well, we'll have you, Karen, then sit down. We're going to move into public comment, and then you can mention your thing because you'll have a rebuttal after you hear from people.
Because I think it'll come up. So,
Okay.
And thank you. Thank you for your time.
Thank you. All right. So now is the opportunity for members of the public who want to speak on this item to come up. So we'll ask you to come up, and you'll have 3 minutes to speak. And please introduce yourself.
Thank you. Is it possible to put back up the satellite image we had up there of the first attachment in my email?
From your email?
My email. Otherwise, I have handouts I could pass out.
Bear with me, I'll try and pull it up.
Okay. So while she's seeing if she can bring that up, I'll introduce myself. My name is Lori Dasko, DASKO, LORI. I am the president of the Lake Knowles Recreation Area. That's it? Yep, thank you. So in the blue there, as Karen mentioned, that is the property owned by the Lake Knowles Recreation Area. Just to recap what she said, Lake Knowles Recreation Area is an unincorporated nonprofit established many years ago to allow non-lakeside property owners on Swain-Sona Drive, which there are about 11, to access boat Bodecker Lake for recreational purposes, typically to launch a kayak or a boat, to fish, or to just enjoy the sunset. As I stated in my original email to Samantha back in September 2024, Lake Knowles Recreation Area is opposed to the granting of this short-term rental license for two main reasons. The first is the increased liability risks that our organization will occur from renters trespassing on our property to get to the lake. It's a very enticing short-term walk to get to the shoreline after you've driven to the property and you can see the lake. You're wondering, what's over there? I'd like to go check it out. So, as she mentioned, there currently is a locked gate at the street entrance to the LKRA property, but there's no existing fence between our property and Karen's property line. Karen has told us that it's not possible to put up a fence along the shared property line because of utility easement restrictions. Karen plans to deter short-term rentals from trespassing onto our property by installing a sign on her property line saying no trespassing and putting into her rental agreement clauses that trespassing is not allowed. While admirable, these may not be enough to deter a short-term renter from crossing onto our property, especially if the members of the party are children. Children tend to be more curious and spur of the moment in their decision making about exploring, and they don't care about signs and they don't care about what's in a short-term rental agreement. In addition, I see today, after reading a draft of the manual that Karen will be providing to short-term rentals, she specifically instructs rentals to use the LKRA property as an emergency exit route. She wants them to walk from her house down to the shoreline, go around the fence, and walk back towards past her house out to the main street. So this may be a valid reason in renters' mind for them to go check out the property. Hey, she's listing this in her manual as an exit route, so I'm going to go check it out. The shoreline is unstable in the area that they're being directed to walk to going around the fence. It's basically a field.
Lori, your time is up, so if you can make a closing statement.
I just want to reiterate, other than noise and trash concerns, which other people have brought up, liability is the main reason why we believe that this application should be rejected.
Thank you, Lori. Is there anyone else who would like to come speak? Good afternoon. You'll have 3 minutes.
Good afternoon. My name's Brad Sutton. I live on the other end of the street, as Karen mentioned. And when I moved in there, we were told that there was access to the lake, and it took us a while to find it. And as part of that, I researched what had happened. Because originally, we were told it was across the street from our house, which it was originally. And then that created problems because when people drive down 402, they see Bodecker Lake and they want to get there. There's a public access across the lake from us. It's typically overrun by people, and so they look for alternative ways to get to the lake. And we see cars with kayaks on top driving down the street all the time looking for a way into the lake. And years ago, when the subdivision was first created, that lake access was there for the people like us on the other side of the street. And it turned into a zoo. There were people having fires and parties and doing whatever because they could access the lake from our access point. It created several lawsuits that were eventually resolved by moving the lake access over adjacent to Karen's property. So now, when you go down there, you can't get to the lake access anymore because there's a fence at the end of the cul-de-sac. But Karen's property is on the other side of that fence, and there's nothing between her property and the lake access to the lake. You can walk for 20 yards and you'll be at the lake. So the concern is now that where before we had strangers coming down and they could see the lake and they would park and party there, the people who are going to rent Karen's property are going to be strangers who can see the lake and walk down to it and create the same kind of disturbance that existed before, which creates a lot of calls to the sheriff's department, creates calls to the people, the members of Lake Knowles Recreation Area, because the people who live around are going to be disturbed by these strangers who decide that they're going to walk a couple of yards from Karen's house down to the lake and trespass. So we're trying to avoid recreation of the same problem that existed when the subdivision was first created, which created not only problems with law enforcement, but it created the whole neighborhood to be at arms against each other and created all these lawsuits. So we will have, if you approve this, a scenario where strangers are going to be going into the neighborhood behind the lock gate with easy access to the lake. And the next thing you know, you're going to have people calling the sheriff because they're trespassing. Thank you.
Thank you, Brad. Is there anybody else in the audience who would like to speak on this? Okay, I don't see any hands raised. Is there anyone online who wanted to speak?
If any members of the public would like to speak on this case, please use the raise your hand function now. No hands are
No
raised.
hands. Last chance for anyone in the audience to speak. Okay, we'll have the owner come up, and Karen, you'll have 5 minutes to rebut anything that you heard here.
Okay, thank you. Lori pointed out that I point people in that picture you've seen a couple of times. The fire department requires me to say, if Swain-Sona is not an option, it's blocked, it's got a fire, they need to be able to get out on foot somehow, some way. And Samantha and I talked about this a little bit. I'm happy to sit down with the fire department or someone to tell me where to do that. But right now, I don't see a way in my corner, considering the fences in each direction, to get out by foot. That was strictly, and it's written in the operations manual. I can grab mine if you want to see it in big letters, in case of emergency only. That would be the only way someone could get out. I didn't think you would want me to say climb over the fence because that's not terribly safe either. But that piece of it, I'm happy to work with the fire department or talk to the neighbor about making an open. That fence, funny as it is actually on my property. So I think we could do an opening on my property to let them out. They're still going to end up trespassing on the neighbor because they're going to have to walk over and go out their driveway. But that was due to the fire department. As far as children being curious, again, you don't see it from that picture that is the lake. I would be happy to put very clearly, as most places, that the parents are responsible for the children. I mean, it's no precedent. Trespassing has been very clearly stated. If I had read something about if you put a sign that there's danger and it's clearly marked, I can put another sign saying danger to trespass. That would be my proposed solution. But again, unless they're totally letting them go crazy, they're not going to go down there because they're not going to see it's down there unless somebody points it out. I don't think they're going to read through the operations manual, but again, I'm happy to correct that and put that there's we can put a hole in the fence for them to access by foot. As far as I want to address the renters and all the chaos that could potentially happen if people get down to the easement, which I think I've taken a lot of steps to keep that from happening. But with Airbnbs, the renters are reviewed. And you can ask for references. Since this is not my primary income and my mission is not to have this rented every weekend or every week through the year, I can use discretion in who I rent it to. And I think with the reviews and screening them, that could avoid a lot of the potential problems of people. I'm also running it for 3-night minimum, and that's how I address that. I'm surprised, and you can tell me if this isn't okay to do, but I want to address one other issue since I have a minute. And I'm surprised they didn't mention it in the call in. There was a huge concern over traffic and number of cars from Tom, who is my immediate neighbor. So I totally get that. I reduced the cars to 4. My home, my family has 5 cars, so 4 is going to maximum written everywhere, and in the renter's agreement should address that as well. Thank you.
Great. Is there anything else? You have 1 minute and 26 seconds.
I have 1 minute and 26 seconds. I would like if you could approve this. I think that there has to be a level of trust a little bit, and in the neighborhood, I wouldn't deliberately. I do have a vested interest here. I'm not going to just bring people in because I'm trying to make a quick buck. I would like to have it rented at periods when no one's using it, so truly I can reinvest it back into the property to kind of beautify a bit. So knowing me since 2019, I do have a vested interest. So thank you.
Thank you. Are there any questions for Karen that you wanted to ask? Karen, I'm going to ask you to stay up here if you don't mind. It looks like that way we won't have you back and forth.
No, this one.
So Commissioner Shattuck McNally has a question for you.
Okay.
Thank you, Madam Chair, and thank you, Karen, for being here to answer questions. And I am curious. When I saw in your manual that you did show that where to go, how to go to lake access, and I have to say, it is hard, even if it can't see it from your house. That's a large reservoir, and I see it every day. And this last weekend, it was packed, and people are parked illegally around the area over there, and it's hard to get in. And I'm wondering if I don't see in the manual where you identify that it's a fee area and how you have to be able to have a pass before there. And I think that would lead to the renters getting a ticket and having issues. And I was wondering, have you thought about putting that in the manual to make sure that they're clear?
I have. I'm sorry, are you done?
Go ahead.
Okay, I'm sorry. I actually did address this. I put in page D and E of what I was going to present today. Actually shows lake access, the actual public access, how people access it.
Yeah.
It also shows directions to get there. And I can't remember if I did it, but I'm willing to add, I looked today to see there are the links for the different events. Because I mentioned Bodecker, I mentioned Devil's Backbone, and I believe I put the links for those areas. If I did not, I can add those so they have to check and tell them, check for any pertinent information. I know with Bodecker, only if you're boating, if you're putting a boat on it, you need a fishing license. So,
So I did see the map. That's what I'm referring to. Then I appreciate you showing them how to get public access. That usually is full. At least it was all weekend. I did see that you did put fun things to explore. There is, even if you do need to have a fee to pay to go on Bodecker to paddleboard. You can't just access it without paying that fee. So it's something you have to do. So it's something, and also Devil's Backbone. And I know you put on there for Devil's Backbone, and it might want to make sure. I think that those people who are coming, they understand that they need to pay a fee because those are resources, and we want visitors to pay their fair share for those. So I know that was on page 422 of our packet, and I think that would be very important to put on. So I'm just wondering if you had considered that making sure those people know, especially if they if they know it's a fee and how much it costs, they might be tempted. I'm always wondering if they'll be tempted to see if they can kind of skirt down the other way. So also, I know you have a wildlife in the manual, but I'm curious, have you thought about how important it is? It is a major wildlife corridor. There's there's nesting bald eagles there. There's nesting osprey there, and there's a large herd of elk year round. Not right now because they're dropping the babies over to the northwest of there. But I'm curious, maybe an extra. Have you thought about putting extra comments in there about the elk that usually will come and play in the water, or they'll come and be migrating around there and they hang out? It's not just a couple elk, but can be 400 to
Hundreds.
500 elk. So I just want to know, I have you thought about that with the renters? Because it's easy to go out and try to take pictures, and it is very much a concern for a lot of folks about the wildlife.
What I would do, and I'm not sure who I asked, what's the best way? I'm trying to kind of find I was trying to follow kind of the guidelines because they give you a very thing. My thoughts would be, yes, I can do an additional page, but I think more signs in the house would be better. I don't think that somebody's going to really study that book. I think they're going to look through it for the information that they need. I think they're going to look very carefully at their renter's agreement, and that's why I keep saying anything really important, the 4 cars, the no trespassing on those easements, those have to be in the rental. I was thinking signs in the house or outside of the house, like you see when you vacation, like be respectful of wildlife, do not approach wildlife. That would be more signage, I'm thinking would work a little bit better, because we have great animals there. We get the elk going, they go down that easement, a lot of them. We also have a fox family. So I would think posting a sign would be a better thing, and I don't know. The reason I'm hesitating a little bit is because I don't know how I get that information to everyone. I don't know if that's something I take a picture of it to show you what I've done, or if that's something that I just send to Samantha, or how I do that. For both things, actually.
And then since you won't be around and you have someone 30 minutes away, and I know the neighbors have concerns about trespassing, and I know you made a comment earlier that you didn't know why folks that are 500 feet away had comments, but since it is a common shared area, I can understand why the rest of the neighborhood would be concerned about folks kind of trespassing and getting onto that, because that puts a liability on everyone. So have you thought about, being a good neighbor and maybe offering the property manager's phone number, or how to contact him, or how to report things, because so that they don't have to go look for it on the website, but they know who to call, and also just to make sure that the folks know that there is a way to log complaints or concerns on the Larimer County website if there is a violation or concerns about that. I didn't know if you had considered that at all.
I would be happy to consider doing that. My understanding was, like, if it gets approved, that would go out to everyone, that they need to have the property manager's information, my information. I can make a point of making sure the neighborhood, or give out flyers that say this is what you do, or this is the link if you do happen to have a problem. Some of this I just am not quite sure. I'm totally willing to do it. I just need to know how to implement it.
So maybe I'll ask the Madam Chair, have staff clarify, is that the responsibility of the homeowner, or the responsibility of the county to get that number out?
So there is a standard condition of approval that we put on all short-term rentals, that upon approval, the property owner shall mail the designated property manager's contact information to surrounding property owners within a 500-foot radius of the STR, and they shall also mail contact information to surrounding property owners whenever the designated property manager changes. So it's their responsibility to do that if they get approved, but we can certainly work with them creating that list of who they need to notify.
Thank you for clarifying that. I knew that was a standard condition of approval, but I wanted to state that publicly. Thank you. That's all I have for right now, Madam Chair.
Thank you. Commissioner Cafalas, any questions?
I have questions of staff at the appropriate time.
Okay. I don't have any questions for you then, Karen. Why don't we let you sit down and we'll have Commissioner ask the questions to staff.
Thank you.
Thank you. Go ahead, Commissioner Cafalas, ask your staff questions.
Thank you. Two issues, Samantha. Maybe you could help me better understand. One is the issue of access. I think it was Mr. Sutton who said that prior to some lawsuits years ago, there was certain access to the lake, and now access is close to where this property is. Could you clarify for my sake, please? What is the public access, and how does that change if there's people with boats or who want to go fishing, that sort of thing?
Commissioner Cafalas, that's a great question. I don't know that I can speak to that directly. If you're talking about the access easements for the Lake Knolls Recreation Area, and who's allowed to use them and who isn't, I can't speak specifically to that.
Okay.
Was that those were
Do you want to ask the applicant if she has some?
But let me
thoughts?
just have
Okay.
a little bit more. I think that's part of it, Samantha. I'm just trying to understand that there was a reference to people coming off of 14th, Southwest 14th or 402, and they would see this lake, and they'd all be driving up in there to be able to bring their paddle boards and everything else. But prior to the lawsuits, there was an official public access place, and then subject to the lawsuit, that has changed. I'm still not clear on that. But
Again, great question, Commissioner Cafalas, and I think kind of staff did meet with our county attorney to kind of see what our level of kind of research we needed to do on that. And since it was not specifically, even though it's adjacent to this property, it wasn't something that we needed to dig into specifically. But I'll let county attorney, it looks like he may want to chime in.
And maybe I'm not understanding your question, but I think there's two things, right? One is how do you get to the property, vehicular access on the road? I don't know that that's a problem. Engineering should be able to clarify whether that's the access to the property on the public road is good or not. The second part about that little slip of land that goes up to the lake, the resolution to the lawsuit, which happened a long time ago, just says that the people have the right to be there. But it doesn't really matter for purposes of this because they're not going to be able to access it anyway. So to the extent that your question is, how can we avoid people walking on that? I mean, that, I guess, if you can find a way to fit that into the criteria and do an analysis under the criteria, then that's really what it sort of comes back to. But I think to the extent that the question is, how do we reference or interpret, or what did this lawsuit mean? I'm not sure that it is of any significance.
so in terms of access for the people that live there, that's one type of access, along Swainsona Drive there. And then it appears that the public in general is allowed access, but that's in a totally different location.
Commissioner Cafalas, you're correct. It's access to the public lake for the general public is limited to County Road 21E.
And where is County Road 21E? On the west side, the east?
Commissioner, it's on the east side. It's on the east side. It's hard to find.
Okay. Well, I think that addresses that first question. Let me try my second one. Maybe I'll have better luck. And that is on the matter of egress, looking at the overhead. So it looks like in the operations manual, there's a reference to in the event of an emergency, if folks need to leave the area by automobile, it shows a route. But if they need to leave by foot, then it shows going along the easement and then coming back down. Can you say anything about that, Samantha, so I can better understand?
Thank you again, Commissioner Cafalas. So as part of the short-term rental submittal documents, one of the things they're supposed to submit is their operations manual. And I believe as the applicant referenced, there's certain required items that we need in that operations manual. And one of those is kind of an escape route. And we specifically ask the county in our requirements, ask for a map of an escape route from the property to a mainline road. An aerial map is what they can use. But I think what the applicant was referencing is that the fire district asked for 2 points of access, which is above and beyond what we normally ask for. And they've shown the road one. And I think the applicant talked about like the second point of egress was to address the fire district's concerns. Because as you can tell, there's only kind of that one road that goes in and splits to the west and the east.
Yeah, I think you've answered my question that there's the primary escape route by vehicle, which is what we require regarding a short-term rental application. And then the Fire Rescue Authority asks for an additional escape route if there's a need to leave the area by foot. Is that correct, Samantha?
I don't know if they specifically asked for by foot,
Well,
but,
it says secondary escape route on foot.
oh, it did, okay. I stand corrected. I just didn't remember what it said, but yes, that would be to address that.
Okay. I believe you've answered my questions. Thank you.
Any other questions, commissioners, for staff or the applicant? Commissioner Shannon McNally?
Thank you, Madam Chair. I'm not sure who, it's for staff, and I'm not sure, it's not a requirement, but when you talk about some of the criteria, and applicants stated that they're only going to be doing it for part of the year, really there's no way for us to track that. And so, it's always easy to say that now versus later. So I'm just wondering, is that, if that's kind of a maximum minimum, I don't know what that looks like. Is that something, I'm looking at you, Frank. I think you understand my question, where I'm headed.
Well, I think if the question is, how can you clarify when that can be used or how many days per year it can be used, you can put in a condition of approval that says can be rented for no more than 90 days or 120 days or whatever you want. You could put it, if it's just going to be in the summertime, you could put it can only be between June and or whatever. You could do conditions of approval along the lines of something like that. As far as just going back to the access thing, you can put a condition of approval for that too if you want to say, it must include a sign that you cannot access this area or whatever. So all of that is stuff that you could add a condition of approval for if you wanted to.
Thank you. And Madam Chair, can I ask the applicant to come up and answer that question? Thank you.
Yes.
Ms. Mead, you had stated that you wanted to only have this rented for part of the year. You said maybe 3 months. Mm-hmm. And so it sounds like that is your intent. Mm-hmm. And so, because you said this is going to be your primary residence. So are you open and willing for a condition of approval that limits how many days a year you can rent this total?
Yes.
Okay. Thank you.
Thank you.
All right. Any other questions for staff or applicant? No, we're ready to go into deliberation. Commissioner Shattuck McNally, I'll let you get started on that.
Thank you, Madam Chair. This is kind of an unusual situation because it is near a very popular recreation area from Colorado Parks and Wildlife, and it is exponentially exploded with use recently in the last couple of years with paddleboarders and boats and hikers and walkers. And the city of Loveland added a trail on the north side of this, which is a further complication because you have Colorado Parks and Wildlife and their access, and then you also have City of Loveland, and that's kind of increased access. And folks kind of going areas that really aren't open. I'm sure it's very hard to police all that. And so I understand the neighbor's concern, and I think that is a concern liability-wise. However, if the applicant was open to a condition of approval, only be able to rent it for 90 days total of the year, if they're willing to put up some signs that say, trespassing, danger, and change the manual and make sure they understand that they have to pay an access for there's access to pay for some of the areas outside, but definitely for Bodecker is a fee use area. Also to add that extra warnings about, the elk that are in the area and not to approach them because the herds are very large. And right now, this time, well, actually 2 weeks ago is the major time for them to be dropping their babies and having their babies in that area. It is between the last week of May and the first 2 weeks of March. And there was two elk that had babies this last month in that area. So I just wanted to, if there can be some of those adjustments and a very clear sign out in either on the fence and in the house to address these issues and that condition of approval for 90 days, I could I could lean towards approving this application if those conditions of approval and my colleagues would be willing to allow those extra conditions of approval. I think
Thank you,
that's all I want to say
Commissioner.
right now. Thanks.
Commissioner Kafalis.
Thank you. So I think I understand about the proposed additional condition of approval having to do with not to exceed 90 days as far as renting. But I'm sure you're frantically working on the language regarding signage and some of the other things that were mentioned. So it'll be helpful to see that in writing. But with those proposed conditions of approval, also given, well, first of all, thank you. I mean, we do greatly appreciate that folks have turned out and expressed their opinions either in writing or here in person. Ultimately, we base our decisions on the review criteria. The two review criteria that were in question were numbers 1 and 2. The short-term rental specific criteria have been met. It is my opinion that with the reduction in the number of guests from proposed 8 to 3, with the issue of ensuring that parking is not on the street and that it is in the driveway, and some of the discussion that we've had today, I believe that those two criteria have been addressed. And with the additional ones, I think that would strengthen the proposal. So I will support this. I can support this short-term rental application.
With the conditions that Commissioner Shattuck McNally had.
Yeah, once we get to see them, there they are.
Okay. And then you had said 8 guests to 3, and I think you meant 8 to 6 for the 3 bedrooms. Is that correct?
Forgive me.
Okay.
Yes,
okay. Just wanted to clarify that.
3
okay.
bedrooms times 2.
Right.
6.
Okay.
Thank you.
All right. Well, I can support the application as well with those conditions. So, I thank everyone for coming out here today. I understand your concerns. Hopefully, some of those concerns have been mitigated. I encourage you all as neighbors to always work together and try to figure out solutions. But it looks like, Karen is willing to, look at different solutions to emergency, egress and different kinds of things. So I think that there's space to work together to fix anything that you feel like hasn't been fixed by the conditions that we'll be approving here. So we'll when we're ready, Commissioner Shattuck McNally. Staff, do you want more time to
We have some draft conditions pulled up, and if everybody has a chance to look at them, if county attorneys reviewed them, planning manager, I think we're good with them if the commissioners are okay with them.
Okay.
Madam Chair, I just have an addition.
Please go ahead.
On number 15, can you put the presence of the elk year round? Just to kind of emphasize that. And then can I just clarify that you'll work with staff or with the applicant to get that notification out? And I think I don't know if we could go ahead and do it to the whole Blackbird Knolls group. So all of them have that number. And I think it would help the neighbors feel, or the people in that area, because it is kind of tight in there really in the long run. And I know they're all worried about that. And it's at least give them that reassurance they have a way to reach out and to have that property manager. So I'm just wondering if we could do that. So
Commissioner Shattuck McNally, staff would be happy to do that. And I do believe the whole subdivision might have actually been included in the 500-foot notification, but if not, we'll make sure,
Okay.
if that's okay.
And I just had a quick question, Madam Chair. On number 16, Frank, do we have to be specific on what the language needs to be on the sign, or will staff review that to see if it's adequate, or what does that look like?
I think the staff can work on getting the sign appropriate. If there's some particular language that you want to ensure is on that sign, then I think now would be the time to say that.
I just want to really stress kind of, I think I see the danger, but it's no trespassing. I just want to really make sure it's very emphasized. This is, and also saying no trespassing, but there maybe no access to lake. Just sometimes I think when you say no trespassing, but I think should emphasize no lake access. It might be another just good way to, or good way to emphasize that.
That sounds fine, Commissioner. I think once, so you're saying on 16 add that the signage must include that there's no lake access.
I think sometimes people have to read things 3 times or really see it clearly to understand. So thank you. Thank you, colleagues, for understanding my concerns about.
Are we good with what we have here?
Yes, I am.
Okay. Commissioner, we're still typing though, I think. All right. One last chance to look at that language and see if you want to change anything, commissioners. It's 2:15s, but I think we can, that's not no, I'm just nitpicking. All right. Well, Commissioner Shattuck McNally, you want to make the motion on this?
Certainly. And again, I want to thank the neighbors and the staff. The neighbors for coming out and stating their concerns, and I'm hoping you could see that the conditions of approval have to be met for this and to continue to be operating as well. So I would, forgive me, Madam Chair, I'm going to pull this back over. Okay, so I move that the Board of County Commissioners approve the Meade Short-Term Rental Administrative Special Review, file number 23-ZONE 3497, subject to the 13 conditions in the packet, and the other 14 through 14, 15, 16, 17, and 18 added on today of conditions approval.
Thank you. There's a motion on the table. Any further discussion on this item? Seeing none, all in favor say aye.
Aye.
Aye. That motion passes 3-0. We're going to take a 5-minute break before the next item. Thank you. Good afternoon, everyone. We are back for our final item on our public hearing agenda, and that is for the Jacobs Conservation Development, file number 21, Land 4170. So that this hearing will proceed as the last one did. We'll have a staff presentation. We'll have 10 minutes for the applicant. We will open to public comment where people have 3 minutes each to speak. Then we'll do a rebuttal. The applicant can have a rebuttal for 5 minutes. Then we'll bring it back to the commissioners for any questions and final deliberations. So with that, is there a staff report for us?
Yes, there is. Justin Curry will bring it up.
Perfect. Thank you. I thought that's might be what he was doing.
Yes, thank you, Jenny. My name is Justin Curry, and I'll be presenting on the Jacobs Conservation Development preliminary plat proposal. The subject property is highlighted up here in blue, which is just east of the Horsetooth Reservoir and north of the existing Larimer County landfill, along the Trilby and Taft Hill Road intersection. The applicant is requesting a preliminary plat approval on 35 acres to create one residential lot and one residual lot with a 2-acre building envelope for the existing single-family home located on the property. And then there's also an appeal to Article 531A for public right-of-way being required in all land divisions. The applicant and owner is Lonnie Jacobs, located at the address for the property, 2941 Living Springs Lane. It's currently zoned RR2, Rural Residential, and it is in the Fort Collins Loveland Water District, the South Fort Collins Sanitation District, and is served by the Poudre Fire Authority for fire protection and fire safety, and is accessed off of Living Springs Lane, which is a private road, which comes off another private road called Hidden Springs Lane. And again, the lot size is 35 acres. Per the land use code, for any properties that are larger, or 30 acres or larger, located outside of a growth management area, they're required to go through our conservation development process. And depending on the zoning district and the availability of public water and public sewer, there is a residual land to developable land ratio. In this case, with the property being zoned RR2 on public water and public sewer. Whoops, let me move that. Sorry. Then it is a 50-50 residual land to developable land ratio. So in this case, a minimum of 17.5 acres must be used for residual land, and which is required to be conserved in perpetuity or used as agricultural land. And the remaining acreage, which would be a maximum of 17.5 acres, can be developed. Building envelopes located within the residual land count towards the developable area, as is the case with this application. As I mentioned before, there is an appeal request to Article 531A, which is public right-of-way required for all roads within the boundaries of the land divisions, in both urban and rural areas shall be public right-of-way. The staff and the engineering department supports the appeal to allow Living Springs Lane to remain a private road, since the land use code only requires this section of the road within a proposed subdivision to be public and cannot require the entire length of a private road outside the subdivision to change to a public road. Staff also wants to avoid having a roadway become a combination of public-private ownership that would create confusion on ownership and also maintenance responsibilities. Neighbor notifications. So notifications were sent to property owners within 500 feet of the project as required by the land use code. No comments were received from the property owners within 500 feet, but after the staff report was created and the agenda published, I did receive several comments from neighbors in the West Ridge Estates subdivision, which is roughly northeast of the subject properties. For standards for per Article 655D1, standards for the preliminary plat review. Again, all these items are outlined and detailed in my staff report. So if either the commissioners or member of the public have more question or clarification on those, we can go over those individually. But basically they deal with, land use, density, location of lots, access, drainage, those basic design standards, along with mitigation of any hazards such as flood or fire, and sewage disposal. This is the article, or excuse me, the criteria for standards for an appeal review. And again, these items are more outlined in detail in my staff report. And again, we can go over those if any commissioners or members of the public wish to go over those. Based on that, Development Service Teams recommends that the Board of County Commissioners approve the Jacobs Subdivision Preliminary Plat, File 21 Land 4170, and an appeal to Article 531A of the Land Use Code, subject to the conditions noted below. And with also have a suggested motion. And with that, I have, if the commissioners have any questions for staff, I'd be happy to answer. And the applicant is also here to provide a brief discussion and answer any questions.
Perfect. Thank you, Justin. Any questions for Justin? Commissioner Shattuck McNally.
Thank you, Madam Chair. Justin, I think I know the answer to this, but could you expand or drill down a little bit more to talk about what this means? The 35-acre parcels is because the state, there's lots of 38 parcels because that's how the state had the laws. But then also, when we start to look at the conservation development site, when you talk about the residual ratio, can you talk about how the residual land can be developed? How can that residual land be developed?
Yes, and you were correct about your comments about the 35-acre lots. Yes, per state statute, if any lots that you create are above 35 acres, there is no planning process to go through, which is the case of this subdivision. It's a 35-acre lot subdivision. So at the time when it was made, there was no county review. And as far as the items allowed on a residual lot, they're usually just related to, per the land use code, what is required for agriculture uses. So if they're growing something or have animals on there, there's agricultural support buildings. So they could have a barn or some sort of loafing shed and things like that. Basically, structures that support the production of whatever that agriculture production is. And then some of those buildings, again, depending on the sizes and stuff, are subject to building permit review.
And so, thank you for that. And I'm just saying this, I know the answer to this, but I'm just saying this for public, so the public can hear. So that residual, when you talk about accompanying uses, it can't be further subdivided into other lots or other activities. Can you expand on that a little bit?
Yes, that is correct. Once this residual lot is created, if it is approved today here at this hearing and goes to the final plat review, that residual lot can no longer be subdivided. I guess maybe in theory they can request an appeal or amend the development agreement outlining the use plan in there, but it'll be left as it is, either again as open space or undeveloped, or an ag use in perpetuity. And then, as I mentioned, in this application is a little unique because there is that building envelope within the residual land that has the existing residence. So within that building envelope, the property owner can put in an attached garage, a shop, or other structures, again, per any reviews required or permits, but it has to be within that building envelope if it's related to that residential use.
That's helpful. That's all the questions I have for now. Thank you.
You got it.
Thank you. Commissioner Cavallo, any questions? Go ahead, please.
Thank you. Thanks, Justin. So regarding the 50-50 split, residential lot versus residual lot, two questions related to that, sir. One is, can the residential lot, my understanding of the application is that it would be subdivided. Can it be further subdivided? Because we talk about conservation developments as to encourage cluster development. So could you say what would happen or not happen on that residential lot?
I imagine you're talking about the new one being proposed, the new lot being created. That is correct. So in order to create a conservation development, how we determine the density or the number of lots allowed, it's a calculation of the minimum lot size of the existing zoning and then I'll get for what the lot size is or the current property is, and I'll get you the number of lots allowed, and then you divide that number of lots by the number of, in this case, 50 or 17 and a half acres, divide that by that acreage to know, how many lots you can get in there. That being said, this proposal is not using their entire allotted density, and so this, per the land use code, the new lot being proposed could subdivide again in the future if it wanted to.
And then my second part of that question related to the lots. I think in some of the public comment there was a reference to enforceability, that when we do these conservation developments, I think the report indicates often we do conservation easements. Can you speak to the enforceability of ensuring that the residual lot will remain open with keeping in mind the 2-acre building envelope aspect of it?
Yes, so I know there is a comment about the conservation, and so not historically, it's not all residual lots have been placed in conservation easements. That is a separate process, and there's some other variables that depends on. As far as how we, as county staff, I guess you say monitors or tracks the existing residual land. There's notes and stuff, or there's requirements outlined in development agreements that's part of the final plat process that outlines. It kind of almost acts as like a deed restriction that, hey, here's what the residual lot A is. And there's a land use plan associated with that, and there's language in that basically mimics what our code says. It says this is what it can be used for, and more importantly, not be used for.
Thank you. That's very helpful. Thank you, sir. May I ask one more question, please? Regarding the appeal to deviate from the standards or requirements especially on the public right-of-way, could you explain that a little bit better? So, and maybe we could pull up the map. Could we pull up the map, because there's the property and then there's a small street. I forget what the name of that street is. That would remain private, but then there's access to the south, access to the north. Could you explain that a little bit, please?
Yes, give me 1 second to bring up the map and share my screen. I'll do that.
Of course. Thank you. Thanks, Madam Chair. I'm sorry.
Okay, so yes, as you mentioned, so if I zoom in here, now the imagery and line work on here doesn't always exactly line up perfectly, so this is just for graphical representation. But yes, there's a portion of Living Springs Lane here. Oh, yes. So you mentioned, there is a portion of again Living Springs Lane here, located roughly on the northwest corner of this property, which comes off of another private road called Hidden Springs Lane, which is over here, which, as you mentioned, connects to the north to, I believe it's called Westgate Ridge Drive, and then again to the south to Trilby, which is the southern boundary of the county landfill down here. And then both Living Springs and Hidden Springs are both private roads.
And where does West Ridge Drive fit into all this?
Yes, West Ridge Drive connects to County Road 38E here, around this large bend that heads up to Horsetooth Reservoir.
All right.
So we have 38E, County Road 38E to West Ridge Drive, and then this is Hidden Springs Road.
Got it. That's
and
helpful.
I believe this is another private road as well off of this Hidden Springs Road here, but not subject to this land division.
Thank you.
Any other questions before we go to the applicant?
I'll hold my questions till after the applicant and public comment. Thanks, Madam Chair.
Okay, we'll ask the applicant to come up, and you'll have 10 minutes to speak. Please introduce yourself.
Good afternoon, Commissioners. My name is Lonnie Jacobs. I'll be brief. All the criteria to do the subdivision, with the county has been met, and I don't know what else really there is to say. Everything's been met. So hoping you'll approve it. Thank you.
You want to wait till after public comment for questions, or does anybody have any questions for the applicant? Commissioner Kafalis.
Well, I appreciate the succinctness of the presentation. I think it's best to hear from the public and see what issues they raise that might amplify what we've seen in the written comments. And then I hope Mr. Jacobs will be paying close attention.
Okay. So I'd like to open up for public comment. If you'd like to give public comment, please come forward now. You have 3 minutes to speak, and we'll ask you to introduce yourself.
Hi, my name is Elsa Nervik. I'm currently on the HOA board for the Westridge Estates HOA. We actually met on Tuesday this week, and I've already submitted comments in a written form, so Mr. Curie has those. But it was interesting because they were talking about the history of this area, and evidently these original 35-acre lots were designed that they would be able to have independent water and from the aquifer, and that was how they were slated. And they weren't originally connected to the city water at all, and then the landfill contaminated their wells, and they had to connect to the city. Since then, we've had problems, okay? So Westridge Estates, so you get off, I call it Horsetooth Road, but it's 38 year, whatever. You get off that and you drive down, do a couple windy turns, and then Hidden Springs goes off. But the remainder of the road goes up a hill, and then it sweeps way down. And you can see it all from Taft Hill. It's easy to see this neighborhood. So at the high end of the street right now, in the summer, they're running at 40 PSI, Fort Collins Water District, bare minimum. And we have fire hydrants up there, okay? None of this has been addressed. And honestly, it's a public safety issue now. So my opinion on this, just hearing, everything from everyone, is that we have to have this addressed before we move forward. And particularly, I was doing napkin math, and I don't know that I understood everything, but if we have roughly 16 acres that can be divided in 2-acre lots, we're talking about 8 additional homes out there. Okay, well, we don't have water for the houses we got now, so this will clearly rear its head even higher if we go to that level of density. And then the other thing is that our road, it's expensive to have a road like we have. So we have a private road, but it's paved, and we have a huge fund. We discuss it every year. We monitor the amount of money. It's hundreds of thousands of dollars to pave our road. And currently those 2 access points that go off of our road, none of those residents participate in maintaining those roads. We pay into the PID out of our taxes every year to manage that road and to maintain that fund. The other thing, too, is that the neighborhood itself, with the HOA, we don't have a managed HOA. We don't have landscapers. We maintain all those roads ourselves. The residents do. And the neighbors in these 2 neighborhoods do not participate in that in any way. So it would be really nice, particularly if they're going to build all these homes and have construction traffic on our road. If they go down to Trilby, we don't care. That's fine. We don't have anything to do with that. They have another access. But from my observation, they use our road. It's more convenient, but they really need to participate in our maintenance, a percentage of it, I would think. They have a lot of traffic using our road, and they pay nothing.
Thank you, Elsa. Your time is up.
Okay, thank you.
We did get all the correspondence too. Yeah.
Excellent, thank you.
Is there anybody else who would like to speak? Please come forward. 3 minutes, please.
Hi, my name is Paul Ellis. I live at 4763 Westridge Drive. Last month I went to the Planning Commission meeting around this thing, and honestly it was very disappointing. There was a lot of, we're not required to look into this, we're not required to look into that, what you might call the ostrich head in the sand approach. There's a question of the feasibility of increased traffic on Hidden Springs Lane, and the engineer at one point responded, If you're only adding one division, we're not required to do the study. If you're doing two divisions, then we will be required to do the study. But Mr. Curry just mentioned that that 17 and a half acre lot can be divided into something like 8 subdivisions. Let's make no mistake, this is not about conservation. This is the exact opposite of it. Lonnie Jacobs knows of what I would call a loophole in the conservation guides that allows you to cut up your land this way and then sell to the highest bidder. You can't fault a man for trying to maximize his return from an investment, but if it is going to create a liability for other members of the community, it is incumbent upon those with fiduciary responsibility to do the proper due diligence to know what that liability will be. Hidden Springs HOA, Westridge Estates HOA, and Larimer County may be on the hook for work done to Hidden Springs Lane in the future as a result of a plan like this going forward. My main question here is, what's the rush? Now, of course, as a member of the community, I'm totally against this. It will change the character of the area. It doesn't make sense. And every single person in the community is against it. Hidden Springs HOA voted 15-2 against it. The only two who voted for it were Mr. Jacobs and the Hansons, who are also, the county's aware, trying to divide their lot. And if Westridge Estates HOA had a vote, it would be unanimous against it. But that is not the objection I'm raising here. My objection is the due diligence has not been done. How can you push forward with something when you know that there are reasonable questions about a dirt road and you're not even willing to do the study? Take the time, do the study, understand what the cost might be, and then you can have an informed discussion about whether to push forward on this. To not do so is a total abdication of responsibility. Thank you.
Thank you, Paul. Anyone else in the audience who wanted to give public comment? Please come up. 3 minutes. Please introduce yourself.
Good afternoon, Commissioners. My name is Mary Kay Malcolm. I'm one of homeowners at Westridge Estates. I actually am original homeowner from 1993, and my property faces west, facing the Hidden Springs lot. When I bought the land, I was assured that no more development would happen behind my property because they were supposed to be agricultural based, 35-acre lots. So here we are in 2025, and that's not the case because some people want to make a financial gain off their properties at the expense of a community. So besides the previous issues that were addressed, that we have no water pressure, the roads, and no due diligence done, one important fear that I personally have is the wildfires in the areas. 35 years ago, so did you plan for drought? Did you plan for all the wildfires happening? No. So the facts that I'd like to state about when you allow more subdivisions in natural or undeveloped areas to increase, you're increasing the wildfire danger, not only to both people, but the ecosystems. And here are the facts from the Colorado government, Colorado wildfire state. My property is at an 8 to 10 fire risk, severe danger. The Hidden Springs properties are at 8 to 10 severe fire damage risk. Some of the younger commissioners, I want you to think of the future. Like, do you want that liability on your hands? That you allow this subdivision? Because like the Marshall Fire, it was a dense subdivision. And what that leads to when you suppress those subdivided areas, it leads to unusual intense fires. And that's why that whole division was wiped out. And so that's what I don't want to happen to Westridge Estates, because again, one person wants to develop their land, make more money, then we found out more people wanted to develop that. So when you're developing land, And what you have to look for, what causes the most risk? Number one, more human ignition sources. 90% of wildfires are caused by humans. Two, you're risking the wildlife-urban interface expansion. And three, you're fragmenting the fire-resistant ecosystems because roads, fences, homes break up these natural landscape, and you're straining our emergency resources because at Westridge, we have one road in and out. We're screwed, to be honest with you, if we have a fire. So I want you to go home and think about that when you're making a decision, because you have our lives to think of.
Thank you. Thank you. Your time is up.
Thank you very much.
Thank you.
Appreciate it.
Thank you. Anyone else that wanted to speak on this topic, please come forward. Is there anybody else who'll want to speak up? We'll have you kind of ready to roll so we can get this going. Anybody else in the audience who thinks they want to speak? All right. Please go ahead.
Thank you. My name is Todd Rogers. I'm an attorney in town, Fisher Brown, and I'm here on behalf of Sandra Bedrin and Stephen Milton, who are Westridge property owners. You've heard the real issue here has kind of been highlighted by the residents, which is this is not a one-off single lot development. And the fear, which is very well placed, is how this double-gated private road access is going to function, first of all, for the subdivision, and secondly, for the neighboring subdivision. You start at, again, it's one thing to add a single property owner to the use of your road, and we can pull up if you can pull up the image, please, of the road system again for the commissioners. That's one thing. When you start getting into multiple future divisions, and we've already heard the possibility for this particular parcel being further subdivided. We're also told that at least one other, probably two other property owners are going down the same avenue, which the county hopefully can confirm. So this is kind of an exponentially growing problem, and the intent of, if everything had been met, as Mr. Jacobs asserted, there wouldn't be a necessity for an appeal to this public road access requirement. And that requirement is in place for very good reasons that are being highlighted by this proposed development. And it's important, as the gentleman who spoke earlier, to, we think, to have a re-examination of this. The Westridge owners did not receive notice initially. They got involved just kind of by hearing about it, and a more thorough analysis is called for and participation because it affects them. They maintain their road. They will be shouldering the burden of these additional users. And the final point I want to make is at the Planning Commission level, there were reference to a lawsuit within Hidden Springs. That apparently there's a court order. It's not part of the record for your review. We don't have any indication. The only thing that's in the record is that the Hidden Springs HOA is fully, and property owners are fully opposed.
Okay.
And
your time is up. Thank you,
you,
Mr. Rogers. Anyone else who wants to speak on this topic in the audience, please come forward.
Hello, I'm Benjamin Oseki. I live in the Westridge Estates neighborhood, and I found out fairly late about this proposal because we weren't notified directly. We found out indirectly through our HOA board. So, I'd suggest as an improvement that people look into who is adjacent to a proposed change to make sure that they're properly notified. In terms of my concerns about this, my wife and I bought this property, with the original zoning and original plan that was in place for the surrounding properties, and we assumed that no revisions would be done to those 35-acre parcels, and that we would be staring at a relatively rural and distributed property around our neighborhood. It turns out that this proposal will significantly increase the density of what we actually can see from our house. And my concern is that further amendments to the density will further accelerate the amount of development that we're faced with. And then finally, the resources that the county provide, or organizations in the county provide, will be strained by this enhanced density. So, for instance, it's been mentioned that the water pressure, especially at the higher elevations of our neighborhood, are really marginal during the summer, and that same water line is used to feed down Hidden Springs Road and then to serve these properties, because it turns out it's not possible to drill a well that yields potable water in those areas. So increased density will mean additional stress on that existing infrastructure. And then finally, the payment for the roads and maintenance of the roads, we're doing that ourselves. And we're concerned that the construction traffic and the neighborhood resident traffic, both of those things will increase the amount of wear and tear on our road segment. Anyway, those are my concerns. Thank you for considering them.
Thank you. Thank you for coming forward. Looks like we'll have another speaker. Good afternoon.
I'm Denise Nervik, and I live at the end of Westridge Drive. It's about 1.5 miles from where the people cut off. I have driven Hidden Springs Road. The first quarter mile, half mile is all right. After that, that road is a 4-wheel drive road. It's terrible. And there's a gate at the end of it. This road, the Hidden Springs Road, has not been maintained properly. And I don't know if they're going to maintain it after they get their housing developments. There's a shortage of water, which has been discussed. Also, the thing that I'm concerned about is we live about 1.5 miles down Westridge Drive. There's about a 2-mile stretch up to Trilby from the mailboxes on our road. What happens if there's a fire or some other emergency and everybody in the development and on Hidden Springs wants to access that one point where the road comes onto our road? What happens when all those people want to zoom out and
and use that access, I think you're going to find that they won't make it. And I'm concerned because I live at the end of the road. But there is no escape route from this area. I'm very worried about that. The fire, when we had a fire recently, the fire started to come over the hill, and we took our things out. But if we had had everybody in the neighborhood and from Hidden Springs Road coming toward that intersection with 38E, I don't think we all would have made it if there was a real fire coming. I have two other concerns. One, Hidden Springs is not contributing to our road. We pay for that road and we keep it up. There's a lot of cars would be coming and trucks. Who's going to make sure that that road is kept up and that they're all contributing? What I want to know is why don't they first, before they go through all this, pave or change the construction of that road up to Trilby so that that is a usable road. If you haven't driven it lately, try it. It's not usable. I think that's the end of what I had to say.
Wonderful.
Thank you very much.
You did perfectly, Denise. You did it right on time. So we are all good. Anyone else who wanted to speak on this topic in the audience? Is there anyone online who wanted to speak on this?
So we do have one hand raised, but if anyone else would like to speak on this topic, please use the raise hand function. Linda Kennedy, you have permission to talk. Please unmute yourself and you'll have 3 minutes.
Thank you. What I'm going to say will sound like a broken record, but I think I have a unique perspective as well. So first of all, your decision is not just a single lot decision, but a precedence that will impact a longer term decision for the development, both with this property and other properties that we'll be looking to subdivide in the future. So I hope you take that into account as you're looking at it in a holistic manner of the overall impact from a longer term perspective. Secondly, my property is at the beginning of the Westridge development, and I submitted some of the water pressure detail that's directly from our property. Our water pressure is marginal on any given day, and normal water pressure for homeowners should sit in the 50 to 60 psi. We run on average in the below 40 and often in the single digits. More concerning is that a fire hydrant that serves our community is at the base of our property. So the water pressure that is available to that fire hydrant has to be impacted the same as the water pressure to my property. So as you look at this, you have to look at the infrastructure, and I don't believe that the safety, infrastructure, and impact to the communities has been addressed with this proposal. So I hope you can look at all three of those issues. Thank you.
And can you state your name for the record, please?
Yeah, Linda Kennedy.
Perfect. Thank you so much.
Thank you, Linda. Is there anyone else online who wanted to speak?
If anyone else would like to speak on this topic, please use the raise hand function. No hands are raised.
No? Okay. We'll bring it back to the audience. If there's the last opportunity, if anybody wants to speak on this topic, you'd have 3 minutes. All right. Seeing no hands raised, we will close public comment. We will give the owner or the applicant 3 minutes to rebut what you've heard, answer any of those questions that have come up.
Did you want 5 minutes or 3?
Oh, did I say 3 minutes? Mm-hmm. Oh, gosh. Okay. 5 minutes. You get 5 minutes.
Thank you. Westridge was created in 1990. Hidden Springs was created in 1989. So all of the lots in Hidden Springs were, when that subdivision was done, they were 35 acres. In the covenants, it was clear that the lots could be further subdivided. When Westridge came in and did their subdivision, as part of getting the approval for that, they knew Westridge, or they knew Hidden Springs was there. They knew all the lots were 35 acres. They knew all of those lots had the possibility of being subdivided. And that's how that subdivision came to be. I wanted to subdivide and started going through the process. Hidden Springs didn't want me to. I actually litigated it, and after I won, there's my parcel and my neighbors, the Hansons. We're both splitting our properties into 2 lots. The HOA since then has voted and removed the ability to subdivide at Hidden Springs. So they voted there'll be no more subdividing properties up at Hidden Springs. These will be the last 2. So there's just one more lot for me, one more lot from the Hansons. And somebody else subdivided, I don't remember, I think back in 2013. So it's been done before. Water pressure, it seems to be a lot of conversation about that. Fort Collins Loveland Water looked at this and agreed to supply the tap for the extra lot. I'm sure they have a way of knowing whether or not they can serve or not. So that's been done. Subdividing mine, I could have added 2 lots, but I didn't. It's just one additional lot. That's kind of it.
Great, thank you. Any questions for Mr. Jacobs while he's up here? Okay, go ahead, Commissioner. Did you?
Could the applicant share, do you have any challenges with, are you using you're not using the well, so do you have any problems with your water pressure currently?
I have no problems with my water pressure, and I am using my well. The fact that it was stated that the landfill contaminated everybody's wells, that's just not true. There's people that live up there. There's how many lots that are on well water. I have a well that pumps great water. The water line was brought in, to have city water, and thus created the ability to subdivide the property because now there's water at the property.
Okay, I think so. I have it this time. Thank you.
Commissioner Gonzalez, please go ahead.
Thank you, Madam Chair. Thank you, Lonnie. Can you speak to, based on the presentation from staff, that the residential lot could be further subdivided to the minimum, I think is 2.5 acres, whatever it is. Is that your intention to actually subdivide this to create 8 lots? And if that is the case, how would that impact? What is your understanding of the impact on water pressure? What is your understanding of the need for a traffic safety study if we're looking at more than just one residential lot?
Yeah. Probably all that would have to be done if somebody was wanting to add more than just one lot. And my intentions are to add 1 lot, never to be subdivided again.
So in the residential lot, your intentions are to build a house that would comprise the 17, whatever the acreage is, for someone to purchase. Is that correct?
Yes. It's 35 acres being split in half, 17.5 acres roughly each. Houses existing on the 17.5, 1 more house will be built on the new 17.5.
Maybe one last question.
Go ahead.
And then later on we'll ask Justin a little bit. So any thoughts, Lonnie, on the comments made regarding the condition of Hidden Springs Road and, shared responsibility for trying to maintain that. It sounds like, as I understand it, sir, that Westridge, that subdivision, that neighborhood, formed a public improvement district, and that's how they're able to do some of that work. And that's part of a mill levy, and you're included in that district. But if you weren't originally included in that district, then you can't just as far as I know, you can't just join up. So, what are your thoughts on the condition of the Hidden Springs Road and access and those kinds of issues that were raised?
The Hidden Springs Road, it's basically the same thing with our subdivision. All the money is spent maintaining the road. One of the requirements that the county had was that the road met county standards, and we actually had them come in, regrade, make sure the side of the road had proper drainage, and is basically county specs had to be met. So we did that. As far as Hidden Springs Road, that's how it's been maintained since I've been there for 20 years.
I think that's all for now.
Commissioner Janik Mayline, did you have anything?
I have some for staff, but not for the applicant at this point.
We'll have you sit back down, and if we may call you back up if something comes up. All right, thank you. All right, go ahead, Commissioner, if you want to talk to staff.
Yeah, thanks. And I'm not sure if this is for Mr. Curry and our Mr. Haglard. My question is, so I'm trying to understand this residual lot thing. So there's a lot that's got the current 2-acre home on it now, and the other lot's going to be subdivided, and it has a building envelope on it. But in the future, that residual lot, once it's sold, the owner of that lot could subdivide it further. Is that true?
You are correct. So I brought the graphic up. So this entire box is how the property sits now at that 35 acres. This residual lot A here is the residual lot. Here is the building envelope, which is just over 2 acres for the existing residence where Mr. Jacobs lives. And then this piece here will be the new lot being created. So they are not using their entire density allotment for this. And so per the land use code, and if the new property owner wished to do that, they could submit an application for a land division or I guess amend a plat to amend this to create that additional density. But as Mr. Jacobs stated in this particular case, the HOA has updated their covenants, which does not allow that. Now the county does not enforce or interpret covenants. So if we get an application that is complete and deemed acceptable, we'll review it. And that's on the applicant's risk to then possibly getting sued by their HOA or sort of legal matters that may come up. But that was a long answer saying, and per the land use code, there is still some additional density. That only this lot 1 could submit an application for. The residual lot A over here, that is done. This is the size and what it's going to look like. Mr. Jacobs can't come in and try and amend the building envelope. Like the residual lot, it can't be subdivided for. This will stay as it is, either again for ag use or remain again non-developer open, or open land, open space.
So, thank you. If I might continue, Madam Chair.
Please go ahead.
Thank you. So you're starting my next question. So we can't, HOAs and them voting, that's all well and good, but we don't enforce those. That is on the HOA to enforce. So someone could still come in with a land use application for that lot 1 and further subdivide it.
That is correct. I may let Frank add more, but yes, we receive an application, we take the application in.
And I want to make sure I'm understanding what Mr. Curry is saying. But the lot 1, the whole idea with the conservation development is that you have a certain amount of density that you can have, right? So they're not using all of the density that they could have on lot 1, so they could subdivide it more. If they wanted in the future, if they sold off lot 1 and somebody wanted to come in, they could come in and apply, but it would have to go through a separate subdivision process. It wouldn't be automatic. They'd have to get approval from the county commissioners to get that second subdivision approved. And all of this is going to be in the public record when that happens. So hopefully that answers your question.
Yes and no. Thank you. But what I'm asking is the HOA and others would then, that would be up to them to enforce their HOA.
That's
And that's not
correct.
for the county.
Correct.
Okay. My next question is, I don't know if it's for engineering or for you, Mr. Curry, that, and I don't know if you can pull up so can you show me, I'm a very visual person as I'm reading all this, where the access for this lot number 1 would be able to access the road? Where, I mean, because they're asking for this appeal, and so it's only partial, it has to be only partial. They're asking for only doing partial, not the full.
Correct. So on this graphic here in the image, so there's it's not the easiest thing to read, but there is an access right here where Living Springs is, this existing access, which is a private easement. And so that right there is the only portion we're talking about from other on the maps we saw where there's Hidden Springs and then Living Springs. This is the only portion that they're requesting to remain private, not turned to public. So if we were to require it to be a public road, this would be the only portion of that entire area, that entire length of road right here that would become public right of way. And so this is the part they're appealing, to maintain this as a private, access and not turn to public right of way, if that makes sense. And then this easement extends to the west to Hidden Springs, which then extends north and south to West Ridge Road and ultimately County Road 38E, and then to the south to Trilby. I can bring up the larger map if you want.
If you wouldn't mind, I'm trying to, there's lots of divisions here and who's not paying for what and who's winning the PID, and so it sounds like it's kind of compounding.
And if I may, while you're doing that, Living Springs Lane, is that accesses the lot would remain private?
Correct. That is correct. And so here, again, so there's a portion of Living Springs here on the subject property, the northwest corner, where this is all private here and extends on their property here. So that's the only piece that we're asking, or they're requesting, in the appeal to remain a private road and not converted, if you will, to a public right of way. And then Living Springs connects to Hidden Springs, which goes north and south to Trilby Road, which again, that's all private, and then heading north, which then connects to West Ridge Road, which is a public road, and as members of the public have stated, it's maintained by a PID that they have for this subdivision. And then West Ridge Road then ultimately connects to another public road, which is County Road 38E.
That's really helpful. If I that helps, so I can see how this gets complicated. So I was reading back, just to remind myself about what the division is, the water, the state's water, I don't remember the formal thing, had said, and then also it was approved for another tap or another water tap, I guess. But it sounds like, I mean, who comes in, and I don't know whether this is for Leah or for who comes in and tests the water pressure and find out if there is adequate water. I mean, we're still dealing with this, is there adequate water? I keep wondering about this. We still don't have anything about adequate water. And I know, because we also have these concerns when there's moratoriums and there's this and there's coming that, and then we look at whether we have to allow more wells, and then, it kind of compounds the.
Correct, yeah. So I can provide a little more clarification just based on the comments we received from the Fort Collins Loveland Water District and then Poudre Fire as well. So I don't have for as far as who tests the pressure, it's up to that's the district, and they have their minimum standards, and so does the fire department, in this case Poudre Fire. And so based on their comment letters we received for this project, I wrote some notes, So PFA requires 1,000 gallons per minute at 20 PSI for fire hydrants that are a fire hydrant within 400 feet of the subject property. And then those pressures and all that stuff is tested with the fire district and the water district at the time of building permit for the lot. So if this is approved and the lot is created, if and when they submit for building permit, they're part of that review process and they test it then. And there's also comments within Poudre Fire's comment letter and other projects we've done that if the water pressure does not meet their standards, then the new homes will be required to be sprinklered. And so that, and again, that is determined at building permits. It comes to, hey, the water pressure doesn't meet our standards, and it's not there for, fire rescue, fire suppression, then the lot would need to do a fire sprinkler system in there. And that's a note that we have on, that's not a unique plat note request or a plat note that we have on our subdivisions.
Okay, that's helpful. Thanks for helping me walk through that because I was trying to pull it all together, knowing that there is some concerns. It sounds like others are experiencing challenges. So, and then my last question for now, so I want to allow my colleagues if they have any further questions, is one of the documents we received. I think actually this was kind of sent several times from a lot of folks. What they had talked about, and I'm just wondering about, and I think this is a question for any of you, so I'm not sure which to answer, but it says the subdivision of one 35-acre lot will result in a precedent that will most likely result in many future lot subdivisions, but there's no evaluation of accumulative impacts as required by Larimer County Land Use Code Section 5.8.6.b. I'm curious about that statement, and does that apply here about future cumulative impacts? Because I'm thinking about the water pressure and the road maintenance and the fire, the fire danger and so on. Can you expand on that a little bit and kind of walk me through that?
Yes, thank you for the question. So when that cumulative effect comes in mind, I feel like that's more if the needed or existing infrastructure, adequate roads, water, in this case, an important one would be sewer line, is in place to support that kind of density. In this case, it is not. There, again, it's a private road. And so all of these 35-acre lots would need to essentially come in on one application so that entire length of road could then be, if you will, converted to a public right-of-way and then meet all those public, those additional higher standards. And then again, for that density to be coming there's water there. There's water, adequate water. But even then, there's a water line. Doesn't necessarily mean there's the water there needed to serve those additional lots. And again, that would be a question for the water district. And then the State Division of Water Resources gets notified of these applications too. So they provide comments because the water districts provide reports to the state on their water supply. And so they review that to make sure that they have adequate supply for what they are committing to. And then with sewer, there is an existing sewer line on the very southern end of the subject property that extends west to the neighboring property, but does not extend north. And so, if again all these lots came in as they come up to require that density, they would need to then pay for that water main to go in, or sewer line to go in, and the necessary easements and all the infrastructure costs. Then also, they'd have to get agreement from the sewer district if that's where they see their growth there, because the sewer commitment letter or comment letter mentioned that they're within their district boundary but not in their current service area, and so that may not be the sewer district could say we do not wish to serve these lots at this time or that kind of density. You need to get a septic tank.
Okay, that's helpful. Thank you.
Commissioner, you have questions you wanted to ask? Go ahead. I'm sorry, we can't take questions from the audience any longer. Thank you. We don't take questions from the audience in a public hearing, just comments. Thank you. Okay, no, you've already given your comment, and so you only get the 3 minutes, but thank you. Commissioner Gonzalez, please ask your question.
Thank you. So, Justin, when in the referral agency comments, and this might be a question for our health department folks, Fort Collins Loveland Water District indicated that they could provide the necessary water pressure. Was that, if that is correct, was that based on one home being built on the residential lot or up to 8 homes being built on the residential lot?
So for the comment letters we received from the water district, in this case, Fort Collins Loveland Water District, they don't, in their comment letters, they just say, yes, we're willing to serve this proposal based on they meet these certain conditions, and one of those is not water pressure. And with the application that was submitted, it was for one additional lot. So they did the review on what is being proposed, not what I guess could be in the future. And so they don't get in that kind of detail on their commitment or their comment letters, excuse me. That typically, because a lot could be created today, and it could take 10 years to, it doesn't know when it could be built or sold. So what the pressure and all that stuff, I think, is done more at the building permit when they actually have a structure going in and going up. And then when the applicant buys the water tap.
I just want to jump in right here because I feel like we are getting to, nothing's been proposed beyond these two right now. We cannot make a decision that looks out into the future to say that this is wrong, because we have to deal with what's right in front of us. It's a subdivision into two lots, 1 into 2. It's, serving one additional home. So we can't, tell me if I'm wrong, Frank, but my understanding is we can't presuppose that there would be any division, whether or not it's allowed by the HOA or whether or not the owner says anything. It's not a matter of sticking our hands in the sand. We're not allowed to say, decide this because we think that there might be 8 homes someday on this property. Is that correct?
That is correct. You have to look at the criteria for this application, and part of, the cumulative impact aspect of it, any other application is going to have to come back in and go through a full subdivision process. And so it's not like you can just have more lots all of a sudden get created. They'd have to go through a full subdivision process, which would involve this same process, and they'd have to come back in, do all the notice over again, do all of the analysis all over again. So, and you can make that clear in your findings and resolution and in your conditions. You can make it clear that that's all. It is anyway, but you can, if you want to, highlight that.
I just wanted, because the line of questioning seems to be that it's automatically going to develop into 8 lots, but we can't jump to that conclusion in this space. We're given this is for the 2 lots, so we weren't asking questions of water districts about 8 lots. We were asking them about this additional lot that's being created. So I guess I just want to just frame that for both the public and for us as commissioners, that we can't say, well, we won't want this to happen because something worse could happen down the road. We have to look at this specific scenario right here that's in front of us, use a criteria that for this particular request, which is 38 acres to create 1 residential lot and 1 residual lot. That is what we're deciding today. So, okay, Commissioner, please go ahead with your questioning. I didn't want to.
No, I appreciate that that input, and I agree that we can't control what may or may not happen in the future. At the same time, I'm curious. I thought I heard the applicant say that their intention was to just create the 1 residential lot, 1 home on that lot rather than subdividing. I thought that's what I heard. And so I think I know the answer to this. I'm sure the county attorney will weigh in. But is that something that either as a condition of approval, or is that something that we can enforce to keep it with what the intention of the applicant has stated?
You're asking if you approve this, if you were to approve this, there would be a subdivision into the 2 different lots. There's a building existing on the 1 lot. They could build 1 other residential structure on the other lot, and that's all. That's all they would be allowed anyway, and that's what's in the application. And so that's all true. And there's a provision in our findings and resolutions that says applicant is bound to all the representations that they've made during the hearing process.
So just another follow-up really quick there, Madam Chair, I know. Thank you, Frank. To make it very clear to the folks that are listening and the folks that are here, if we were to approve this, we are approving a 35-acre parcel to be divided into a residual lot with the current building envelope of 2 acres. That residual lot, no more development could occur on that residual lot. On the residential lot, the proposal before us is to put one new home on that. If the applicant were to consider subdividing, that's a whole new process.
That is correct. I want a little clarification about this on the residual lot. If there is some ag use going on, they can have, agricultural support buildings and structures like that. So I want to make sure that folks know if they see a barn going up or something, that is permissible under the land use code for residual lots.
So I appreciate the planner confirming that. Does the county attorney confirm what I just said?
Yes.
Okay. Further questions? Commissioner Shannon Valley.
Frank, as my head was spinning with other questions, you had said a little earlier about we could state something to make it really clear in the findings resolutions before this. Can you remind me what you had said?
Well, I mean, I think it will be clear anyway. I mean, if you wanted to put a condition of approval that said one residential structure is allowed on the residual lot that already exists, and only one additional residential structure will be allowed on the newly created lot. You could say that. That'll be true anyway, but you could put that in there if you wanted to.
And it has that specific building envelope there up by the access, right? It has to be near the access, or can it be anywhere?
That's the existing house, right?
Correct. The existing house is in that building envelope on the residual lot A. The new lot being created is, has, a little, the 115-ish acre. There isn't a building envelope on that. So they're subject to the RO2 zoning setback standards for property lines. Okay. And then if there's any easements or anything else, then that could possibly prohibit location of development on the property to be subject to, but that would come up at building permit stage.
Okay, that's helpful. Thank you. That's all I have, Madam Chair.
Thank you. Any other questions? Go ahead.
Thank you, Madam Chair. So just one additional question, and I believe I know the answer, but I want to make sure. So when I think a couple of folks brought up about the due diligence matter, and maybe it was Mr. Ellis or other folks, regarding the need for a traffic study. A traffic study would only be needed or required if there was greater density on any further development or subdivision of the lot. But we're saying that that's in the findings and resolution. That's already clear that we're talking about one new house on the residential. Go for that one there, Justin.
With regards for, I guess, the standards or when a traffic study is required, I'm going to reach out and let my colleagues from engineering discuss that.
Yeah, so this is in the rural area, so we'd be using our Larimer County Rural Area Road Standards. Section F114 talks about requirements for traffic impact studies. Specifically, it stipulates any proposed development or land use action which creates less than 3 new dwelling units or generates less than 21 new daily trips will not be required to submit a traffic impact study. Such development would, however, be required to pay transportation capital expansion fees in effect at that time. So that's kind of what we look to on a development like this. They meet the criteria to not have to submit a traffic impact study.
For the current proposal that is before us.
Yes, that's correct. But as Commissioner Stevens, I think, alluded to, we can't consider, like future potential developments as a part of this one. We're just looking at one new lot. And even with the knowledge that there's a similar development happening right next door, actually those two together, each creating one new lot, still meet the review criteria. We can't technically do that, but even together, they're still below the requirement for not needing a traffic impact study.
Thank you.
Further questions before we go into deliberation? Commissioner Cavallo, I'm going to let you get started.
Okay. Thank you, Madam Chair. Thank you to everyone. I guess what it comes down to is, in light of the discussion, in light of the information, and and the clarification that we are looking at this particular parcel would be divided into two lots, one residual, one residential, with one home new construction. I will support this application with that understanding. I would like it to be a further clarification be included in the findings and resolution to make it very clear, even more so, that that's what we're talking about. So based on discussion, based on the review criteria, I can support that.
Thank you, Commissioner. Commissioner Shannock McNally.
Thank you, Madam Chair. I want to thank everyone for coming out. I understand, I live in unincorporated Larimer County. I know and understand how it is when things start closing in and coming closer. And I know that's why we have land use code and standards and have criteria so that everyone has a fair process. And what we have before us is a criteria that we have to apply, and we have to follow that. It doesn't give us a lot of discretion outside of that. And so I did have some concerns about this because of the complexities with the different road associations and the PID and the private roads. It seems like it gets a little complicated. But as we were talking, it seems like there's just going to be one other home or one other lot. And so I agree with my colleague, Commissioner Kafalis, that I'd like to go ahead and have that. Frank offered to have that clarified. I think I'd like to have that spelled out and clarified in the findings and resolutions. And I guess I think the staff recommendation on the appeal makes sense, and so I can support that as well. This is certainly an area of concern, and but I do feel that after this discussion and this presentation, and staff, I appreciate you answering our questions. I appreciate the public being here and asking appropriate questions and sharing their experiences, because I think they're valid concerns. And I hope you'll stay engaged and keep asking those questions. So with that added addition of approval, I can support this going forward.
Thank you, Commissioner. I'll also be supporting the application. Did want to thank everybody who came out today, though. We are sort of tasked with what's in front of us. This is not for eight new homes to be built, but it's just for this residual lot and this residential lot. And so that's why there's no traffic study, as you've heard. That's why we can't do cumulative impacts. It's one additional residence that would be built. There are those things would come into play if there were any kind of application for more density. And I understand your concerns about the density. I mean, I think you brought up some really valid concerns. And if there were more density in this case, we could look at those items. But there just isn't that kind of density that requires us to look at that in this particular situation. So, I think that if there's any other spots that come up that are near your home that are looking at that density, I think that all these arguments are certainly valid. So I want you to know that we heard you, and what we're looking at is not that kind of density that brings up any of those concerns. We also have to, honestly, we take the water district at their word, and so we have no way of kind of poking into the business of the water district. They're their own governmental entity, and they make their decisions about their water infrastructure. Same with the fire department and their requirements for pressure. We have to take these folks at their word. But it doesn't preclude.
Clearly, you do not support further density. Why not put that in? You
All right, excuse me, sir, you're out of order, and so we don't do this. This is so consider this like a hearing, right? This is quasi judicial. We don't speak out. We don't get to, if you want to have further conversations with any of us, whether it's staff or us, that's fine. We're just not going to do that right now and right here. I think that what the commissioners are calling for, with an additional statement in the findings and resolutions, is in some ways doing that. So anyway, like I said, we're given the task of interpreting the code with this particular situation in mind. It sounds like we're all in support of this. Can I ask the county attorney, do we need to state the what we want to add to the findings and resolutions in the motion? Would that be beneficial?
My understanding of what the commissioners want to add is that there would be only the residents on the existing residents in the building envelope on the residual lot, and only one additional residence on the newly created lot. And then that's what we'll put into the findings and resolution.
Does that sound right, commissioners? Okay. Do we need to include that in the motion at all, though, Frank?
I'm sorry, what was your question, Commissioner?
Did any of that need to be, do we need to include that in the motion, or that's been picked up by the record and that'll be reflected in the findings and resolutions?
That will be reflected in the findings and resolution.
Perfect, thank you.
Madam Chair, I think
Please.
when we had the discussion, I thought Commissioner Kafalis and I, because, and I'm Frank, correct me if I'm wrong, but you said we could add it as a condition of approval to make it clear, so we could add it as a condition.
Yes.
And not just in the finding resolutions, but add it as a condition of approval, so it's stated out.
Right.
That's what I was supporting. I thought that's what Commissioner Kafalis had wanted as well. So
maybe it's I misspoke, because the conditions of approval are part of the findings and resolution, so it will be a condition of approval in the findings and resolution.
Are you fine with that?
Yeah, I just want to make sure it was spelled out in a condition of approval.
Okay, looks like it is then. All right, are we good here? Sir.
So, Madam Chair, so the suggested motion outlining the staff report and the additional condition of approval, and I don't know if we needed to type it out, because it says in the staff report, and this extra spelling out, this other extra condition about that is not in the staff report, so I didn't know if it needed to be, and the condition of approval about the single. If we're going to spell it out as a condition, don't we need to? It's not in the staff report currently.
As long as somebody mentions it in the motion, I think the aspects of the deliberation talking about it are sufficient.
Okay. So Commissioner Sheddick-McNall, you want to make that motion, and then you can mention that as well.
I think I made the other motion, but I'll be happy to do both of them, but I'd love to share the wealth with my colleague.
You're up, Commissioner Kafalis.
So I'm to make the motion that is before us?
Yes, that is correct.
I move that the Board of Commissioners, the County Commissioners, approve the Jacobs Conservation Development file number 21 land 4170 and an appeal to Article 5.31.a subject to the conditions as outlined in the staff report. And an additional condition that will be part of the findings and resolution.
Correct, as mentioned, as I just mentioned. I'm assuming is the condition you're talking about. About only the two houses, one on the existing lot and one on the new lot.
Yes.
Correct.
Okay, thank you for that clarification. There's a motion on the table. Any further discussion on this item? Seeing none, all in favor say aye.
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 That motion passes 3-0. That is the end of our business to become before us in this land use hearing. And so at 5:37, we are adjourned. Thank you, everyone.